Good afternoon. I would like to welcome and thank each of you for joining us on today's capability webinar, Medical Marijuana in Canada, Weeding Through the Risks and Opportunities. My name is Crystal Dahl and I am the Online Communications Specialist here at Maritas. Today's webinar will be presented by Trina Fraser at our Ottawa, Ontario, Canada Maritas affiliate, Brazo Seller. Trina's broad legal practice includes business and commercial law, regulatory law, internet and e-commerce law, and trademark law. She negotiates and drafts a wide range of business agreements, including purchase and sales agreements, intellectual property licenses, commercial leases, shareholder agreements, non-competition, non-disclosure agreements, and marketing distribution agreements. Her diverse array of clients has ranged from real estate brokerages and restaurateurs to some of the world's largest online casinos, and Trina is currently assisting clients seeking to become licensed producers of medical marijuana in Canada. In addition, Trina is a registered trademark agent and provides counsel to her clients in protecting their intellectual property rights. Before we get started, I would like to quickly go over a few housekeeping items. As many of you have already likely noticed, all telephone lines have been muted. If you have a question for Trina, you are welcome to ask her via the chat feature found on the left-hand side of your screen. Trina is planning to answer all questions at the end of her presentation. If you experience any technical difficulties, please press *0 at any time to connect with a support technician. With that, Trina, are you ready to get started?
Sure am.
All right, great.
Okay. Thanks everyone for joining us today, and good afternoon to everyone. I think it's afternoon for most of you actually. I'm happy to be speaking to you today about the medical marijuana industry in Canada. We've got a pretty diverse audience with us today, lawyers both within Canada and outside of Canada, as well as a variety of industry participants. So I'm going to do my very best to provide information that's going to be of interest to all of you. So by way of overview, well actually first for clarification purposes, you're going to see that right on the first screen I've spelled marijuana two different ways. In the Marijuana for Medical Purposes Regulations, which is the primary piece of legislation I'm going to discuss today, it's spelled with an H. That's an antiquated way of spelling the word marijuana, which nobody else uses except the federal government in Canada, and in fact Health Canada doesn't even spell it consistently, because if you look on their website, they use both versions, and in the recall notices they've issued recently, they spell it with a J. So I'm going to just spell it with a J, notwithstanding the fact that the Act spells it with an H. So by way of overview, and my intention is to speak to you for about 45, 50 minutes. Hopefully I can squeeze everything in within that time frame, and then I'll leave a little bit of time to answer questions as best I can at the end of the presentation. So by way of overview, I'm going to explain to you how marijuana is regulated by law in Canada. We're going to then look specifically at the Marijuana for Medical Purposes Regulations, which I'll refer to as the MMPRs, which are the current regime for medical marijuana in Canada, how you become a licensed producer or an LP under the MMPRs, what some of the challenges and risks and opportunities are for LPs under the MMPRs and other parties who might be interested in this industry, and then just a few of my thoughts looking forward. So marijuana is regulated in Canada at the federal level. So we're looking at a federal act called the Controlled Drugs and Substances Act. Section 4 sub 1 of that act says that no person shall possess a substance included in Schedule 2 except as authorized by regulation. If you contravene that, you are committing an indictable offense. Schedule 2 includes cannabis, its preparations, derivatives, and synthetic preparations. And it also specifically mentions certain cannabinoids. Now cannabinoids, there's about 85 different cannabinoids present in the cannabis plant, but the two that are most readily known are tetrahydrocannabinol, or THC, and cannabidiol, or CBD. So THC is what gives you the high. It's known to assist with symptoms including pain, appetite loss, insomnia, nausea, helpful for the treatment of depression, whereas CBD has no psychotropic effects but does have significant potential medical benefits because it's been shown to have anti-inflammatory, antioxidant, and neuroprotective properties. And CBD in particular has really come to the forefront in the media in the past year. You've probably heard stories in particular of relating to Dr. Sanjay Gupta's documentary Weed, which aired on CNN last year and really brought to the forefront the potential medical uses for CBD and highlighted a particular case where CBD was used very successfully to treat childhood epilepsy. So we're hearing more and more about that in the media. So one of the regulations to the CDSA is the narcotic control regulations, and those regulations also say that no practitioner shall prescribe marijuana except as authorized under the MMPRs. So you can't possess and a doctor can't prescribe to you unless it's permitted specifically by the regulations. So cannabis has been a controlled substance in Canada, in fact, since 1923, which was 14 years before the U.S. regulated it. It was lumped together with heroin and codeine to add to a list of controlled drugs. And the thing that's interesting to me about this is a little bit shrouded in mystery. It was approved by the House of Commons and the Senate without any apparent discussion or debate. So, and it was a little unusual as well that apparently at the time no one was really smoking marijuana in Canada. It hadn't been labeled as a social problem, so it begs the question of who wanted it added and why, and nobody really seems to agree on that at this point. But I do think it's ironic that we're so vigorously discussing regulation and decriminalization now when the initial criminalization of it in the first place seem to have not been subject to any discussion or debate at all. Since 2000 in Ontario, in Canada, really it was the Ontario Court of Appeal decision in R.V. Parker, which led to the creation of a medical marijuana regime in Canada. So from 2001 to 2014, this was through a program called the Marijuana Medical Access Regulations, or the MMARs, which was an exclusively government-run program, and I'll quickly overview how that worked. And then April 1st, just this year, the MMARs were replaced by the MMPRs. So in R.V. Parker, Mr. Parker had suffered from epilepsy his whole life. He had tried various forms of treatment and medication, ultimately found that marijuana was the only thing that gave him any substantial degree of control over his seizures. He grew it himself in his home. This ultimately led to him being charged, and he defended the charges on the basis that his constitutional rights had been violated. So he claimed that his right to life, liberty, and security of the person under Section 7 of the Canadian Charter of Rights and Freedoms had been infringed. So he was successful at trial. The charges were stayed, and the judge at trial read into the CDSA an exemption for people possessing or cultivating marijuana for personally medically approved use. This was upheld at the Court of Appeal, which struck down the prohibition on possessing marijuana in the CDSA, but suspended the invalidity declaration for 1 year in order to give the government a period of time to put a regime in place to govern this personal medically approved use. So that ultimately led to the establishment of the MMARs in 2001. So under the MMARs, the way it worked was you first had to get a declaration from your doctor. And basically that declaration was your doctor confirming that you had what was referred to as a Category 1 or a Category 2 symptom, and that conventional treatment for those symptoms was ineffective or inappropriate. So Category 1 symptoms included a symptom related to end-of-life care or related to MS, spinal cord injury or disease, cancer, HIV/AIDS, arthritis, or epilepsy. And then a Category 2 symptom was any debilitating symptom that was related to any other medical condition. So that could capture a wider array of conditions like depression and anxiety. So you could take your, I should go back for a sec. Once you had your declaration from your doctor, you could then apply to Health Canada for what was called an authorization to possess, or an ATP. Once you had your ATP, then you had to get access to marijuana in one of three ways. You could grow it yourself through a personal use production license or a PPL. You could have someone else grow it for you, and they would obtain a designated person production license or a DPL, or you could purchase it directly from Health Canada, and they had Prairie Plant Systems in Saskatchewan was their exclusive supplier. There was no restriction on where you could produce. It could be outdoors as long as it wasn't near a place frequented by minors, and it could be within a residential dwelling. MMPRs were repealed on March 31st this year and replaced by the MMPRs. Under the MMPRs, dried marijuana must be produced by a licensed producer. So no more personal production, no more designated growers. You have to buy your medical marijuana from a private entity which is licensed to grow and sell. Now, Health Canada has cited a number of reasons for switching to the MMPRs. I think there was about 40,000 people licensed under the MMARs. I don't think they contemplated that volume of licensees, and we're finding it administratively difficult to properly monitor and supervise. There were concerns about risks of electrical fires and mold in dwellings that were used to grow marijuana, and there certainly was a concern about diversion to the illegal market as well. So what they were finding was that personal producers and designated growers, although they were growing within the scope of their license, it was producing more dried marijuana than the person was actually going to consume, and the surplus was getting diverted to the black market. So now, in order to access medical marijuana under the MMPRs, you have to get a medical document from a medical practitioner, namely your doctor, and then you take that document and you provide it to the licensed producer of your choice, and you are able then to purchase dried marijuana directly from them. Now, although this is Health Canada's own regime, you'll see that they don't exactly give a ringing endorsement to the use of marijuana for medical purposes. And on their own website, they tell you over and over again, dried marijuana is not approved in Canada, and it's certainly not endorsed by the Government of Canada. So as of May 20th, there were 858 MMPR licensed producer applications submitted to Health Canada. Of those, 370 had been returned as incomplete, 149 had been refused, 30 had been withdrawn, and 13 or somewhat more than 13 were actually licensed. I'll talk about that in a second. Which leaves about 300 applications pending, and apparently about 25 new applications being submitted per week. So I don't think it's a stretch for me to say that Health Canada is a little overwhelmed right now. With respect to the producers that have been able to achieve a license so far, there's been 5,120 patients that have actually registered with them. Now, while there are currently 13 licensed producers listed on Health Canada's website, there are more that have been actually granted a license. I'm not sure how many more. And the reason for that is you don't actually have to be listed on Health Canada's website until you have product that's available for sale to the public. So there are companies like ABCan, which is based in Napanee, Ontario, who are publicly stating that they're fully licensed. They just don't have product ready to sell yet. There's always going to be that lag between when you get your license and when your first harvest is ready for sale. There has been one suspension thus far, and that's Greenleaf Medicinals, which actually now is rebranded as Broken Coast Cannabis. And they were suspended after a surprise inspection which revealed some production difficulties. So there's a lot of pending applications. I've been hearing a lot of frustrations by applicants over what they perceive as delays on Health Canada's part. There's been no new licensees listed on Health Canada's website for a while. And from Health Canada's perspective, they're just not going to move any faster than they can in order to make sure that their rigorous licensing and safety standards are met. And I guess they're doing the best they can. So the key changes from moving from the MMARs to the MMPRs, again, Health Canada no longer sells or produces medical marijuana. It no longer approves the patient's right to access dried marijuana. So again, you don't submit anything to Health Canada. Your medical document is submitted directly to the licensed producer you intend to buy from. The only legal source of dried marijuana is from a licensed producer. So there's no more personal production. It's subject to an injunction, which I'll talk about later. And production is only permitted indoors in a non-residential site. So no more growing in homes. There is an expanded class of persons who can prescribe medical marijuana or provide a medical document. The defined term is medical practitioner, and that includes not only physicians, but nurse practitioners who are practicing in a province that permits this. Currently, there are no provinces that permit nurse practitioners to provide medical documents, but it looks like Alberta and BC are phasing in an ability for nurse practitioners to prescribe various narcotics, and eventually this may include medical marijuana, so we'll have to stay tuned. But this should be of interest to licensed producers because it would open up a whole new category of individuals who would be authorized to provide medical documents. So once you have your medical document, you have to deliver it, the physical copy of it bearing your doctor's original signature to the licensed producer. You cannot deliver it electronically or otherwise. And there's no restriction on the types of eligible conditions or symptoms as we saw with the MMARs. It's really just up to your physician to determine that it would be appropriate to provide you with access to medical marijuana in their discretion. So what this has created with the MMPRs is a free market and a privatized market for medical marijuana, essentially subject to the regulations. The licensed producers are free to set whatever prices for medical marijuana that they want. Initially, leading up to the April 1st commencement, there was forecasts of the $9 to $12 range per gram. I think that's pretty much borne out, although we're certainly seeing some strains sold at prices significantly less than that. Under the MMARs, Health Canada only sold one strain of marijuana, but there's no restriction under the MMPRs for the number or types of strains that can be sold by a licensed producer. So that provides an ability for licensed producers to differentiate themselves according to the types of strains that they develop and sell. However, the MMPRs, as with the MMARs, only permit the production and sale of dried marijuana. So extracts, derivatives, edibles, all prohibited under the MMPRs as they were under the MMARs. The one caveat to that is in British Columbia. So in 2012, the BC Supreme Court rendered a decision in R.V. Smith which removed the word dried from the MMARs so that any form of marijuana could be possessed or produced. So Owen Smith was basically a baker for a medical dispensary in Vancouver. Police received complaints of a strong odor, showed up, saw marijuana, and arrested him. He defended the charges on the basis, as well as similar to Mr. Parker, that his Section 7 charter rights had been violated. So the Crown argued that the dried marijuana restriction was reasonable and required because they wanted to prevent derivatives on the basis of a lack of quality controls or standards, or a risk of overdose, or a heightened risk of diversion to the illegal market, because once you convert it into something else, there was a concern that the authorities couldn't readily identify or quantify it. So the courts considered whether this restriction, which served the state's interest, outweighed the individual's choice on how to take their medicine. They found that the restriction actually didn't do anything or much to advance the state's interest, that the restriction was arbitrary and did violate the charter. So ultimately the charges against Mr. Smith were stayed, but not surprisingly the Crown appealed the decision to strike out the word dried. And that appeal was heard by the BC Court of Appeal last November, and we're still anxiously awaiting a decision in that case. So for the time being, if you look on Health Canada's website, they will acknowledge that residents of BC, so long as they are otherwise authorized under the MMARs or MMPRs, are able to possess and produce marijuana derivatives. But outside of British Columbia, that restriction still applies. And notwithstanding the decision in Smith, the dried marijuana restriction still appears in the MMPRs. So we're anxiously awaiting that decision and to see where that goes, because that could open up a whole new market for derivatives and edibles to licensed producers. So if you have a licensed producer, a license under the MMPRs, it will permit you to do things like possess, produce, sell, provide, ship, deliver, transport, and destroy marijuana. LPs can sell to each other. They can also import and export from Canada with the applicable permit. And the permissible applicants for a license can either be an individual who's a resident Canadian adult. I haven't seen that myself, but more typically it would be a corporate applicant. Just must be a corporation with a head office or a branch office in Canada. The key individuals that you have to identify in your application include the senior person in charge. That's the person who's going to have overall responsibility for the management of the LP. The responsible person in charge and their alternate or alternates. This person must actually be at the license site supervising all cannabis-related activities. And what we're seeing is these key roles and other key roles in the organization are being filled by prominent individuals. And this isn't surprising, I guess. I guess it can be seen to add some legitimacy and prominence to the licensed producer or the applicant. But we're seeing former police chiefs as head of security. We're seeing former Premier of BC as chairman of the board for an applicant. Ontario's former health minister, George Smitherin, has submitted an application. We've got even former Prime Minister of Canada, John Turner, on the board of an applicant. We've got Olympic gold medalist Ross Rebliati being the namesake for an applicant, and some strains that are being produced. So certainly a lot of high-profile individuals involved, which is getting a lot of attention. The quality assurance person, the QA person, I should also mention, their job is basically to ensure compliance with the good production practices that are required by Division 4 of the MMPRs. Back in February, I asked Health Canada whether a person could act in the capacity of a QA person for more than one licensed producer. And the response that I got was that the QA person just had to be available on a regular basis to confirm compliance. But in early May, Health Canada changed its position, sent a notice to all applicants that had QA persons named in their applications who were also named in another application, that they had determined that a QA person could only be responsible for one proposed site. So if you were in that situation, you were required to ensure that your QA person abandoned that role for other applicants, or you were required to find a new, discrete, and unique QA person for yourself. So that's just one example of how some applicants are feeling frustrated by what they feel are constantly moving targets that they're having to reach and meet for Health Canada to be able to provide them with a license. Now, the license site itself, I think as I mentioned, it can't be in a residential dwelling any longer. Fire risk, security risk, mold, et cetera, were the reasons behind that. And everything must occur indoors. And prior to submitting your application, you have to provide notice to your local government, fire authority, and police force to advise them of the proposed MMPR activities at the site. And the one thing I wanted to mention to you today, because I don't think this is necessarily apparent to everyone, is that applicants are certainly being advised, get municipal approval, get a letter of support, submit it with your application to make sure that, Health Canada approves your site. That's good advice and it's certainly helpful, but I just wanted to point out that it's not necessarily determinative. As part of its assessment process, Health Canada will conduct its own site assessment of your proposed site, and they reserve the right to reject it for their own reasons, notwithstanding the fact that your municipality has approved it. So Health Canada is going to look at zoning of your property. They're going to look at zoning at the surrounding properties. They're also going to look at how many residential dwellings exist within a 500-meter radius of your approved site, of your proposed site. They're going to look at what kind of a zone it's in. They seem to have more of a concern with agricultural zones as opposed to industrial ones. And there's not going to be any one factor that's going to carry the day, but they're going to do a multi-factored application-specific assessment in each case. Once they determine, in their opinion, that a site is unacceptable, it's unacceptable forever, and no future application for that site will be considered. There's no appeal process from that determination provided within the MMPRs. So if you really wanted to challenge Health Canada's determination that your site was unacceptable, I guess a judicial review application to the court would be your only option. So that's certainly a risk going forward, is that even if you've gotten your municipal approval and you believe you put everything together in your application that's needed, there's still that site-specific risk that Health Canada just for whatever reason won't like your site. So how do you manage that risk? I think one way is to understand that you don't need to construct your facility or do your retrofit or renovations before you have ready-to-build approval. In fact, your application can be on the basis of vacant land. Obviously you need to put your plans and specifications together with your application, but you don't actually need to build your proposed site. And you don't need to do so until you get notice from Health Canada that you've passed that site assessment. The other thing that you can do is think about how you're locking up or securing your property. So as opposed to an outright purchase of the land, what you might consider is a lease initially, ideally with a termination right in favor of the tenant if the ready-to-build notice isn't obtained within a certain period of time, and then with an option to purchase the property later. Now, I understand that may not be available in all cases, and it'll depend on the particular circumstances of the deal, but that I think would certainly be the gold standard as far as managing your risk. So some of the other requirements that you're subject to obviously pertain to things like security, good production practices, which is contamination issues, pest control, sanitation, testing, recall procedures, packaging and labeling, shipping, record keeping, and registration. So what your application has to outline and establish for Health Canada is how you are going to meet all of these requirements. And that's why you hear applicants saying that their application packages are several hundreds of pages in length. There's a lot that needs to go in there. So Health Canada has provided me with their 6-step process for processing applications. So step 1, they say, is screening. This is just making sure that you've submitted all the relevant information and required documents. If you haven't, they send it back to you as being incomplete. So once you've got a complete application submitted, they'll then send off your security clearance forms for processing by the RCMP. So your senior person in charge, your responsible person in charge, and any alternates and any officers and directors of the applicant company or the individual applicant have to all obtain security clearance. The time to obtain security clearance is proving to take several months, and nothing really you can do to expedite that. It is what it is. Once you get all your security clearances, that's the point at which Health Canada is really going to take a good hard look at your application. They're going to verify and validate information that you've provided. They're going to assess your security plan. They're going to actually conduct the site assessment I spoke about. And they're going to go through everything with a fine-tooth comb. Assuming that passes muster, then you're going to get what's called their ready-to-build approval. And that's basically them telling you that if there is still construction required with respect to your premises, and if you do complete that construction in accordance with your plan that you've submitted, that you'd meet the requirements of the MMPRs. So you go, you do your retrofit, your construction, you advise Health Canada, it's ready to go. They will then come, apparently at one point in time they'd saying they'd be there in a week to 2 weeks. I don't know if that's still the case. But they will come and do a very, very detailed inspection of your premises. If any deficiencies are identified, obviously they would need to be corrected. And once you have corrected any deficiencies to their satisfaction, your license will issue. So the important thing to remember about this 6-step process is that Health Canada considers it to be linear. They will not do anything with respect to step 2 until step 1 is completed, and so on. And so you really are kind of stuck on that track. So while applicants, I think, were initially budgeting about a 2 to 3 month time frame to achieve a license, I think that's proven to be a gross underestimate of the actual time frame that's more realistic. So the minister, according to the MMPRs, must issue a license if all the required documentation has been submitted and security clearance is obtained. But they must refuse to issue the license in certain circumstances. The two I wanted to point out to you in particular are, one, where information has been received by a peace officer, competent authority, or the United Nations, which raises reasonable grounds to believe that the applicant has been involved in the diversion of a controlled substance. So note that it doesn't mean that the applicant has ever been charged or convicted, just means that there has to have been reasonable grounds to suspect you were involved. The second one is that the issuance of the license would likely create a risk to public health, safety, or security, including the risk of cannabis being diverted to an illicit market or use. This is, I think, the minister's most powerful tool because it's so broad and imports such a great degree of discretion. And that very broad language about creating a risk to public health, safety, or security also applies to the cure provision and the suspension provision and the renewal provision. So we see it over and over again repeated. So it's going to be interesting to see how broadly Health Canada is going to interpret their right under that section, and whether that interpretation will ultimately be challenged in court. I know I've already seen one case where a refusal was based on that very provision of creation of risk to public health, safety, or security. And when I pressed Health Canada for a more detailed understanding of how they reached that conclusion, the response I got was less than satisfactory. So I think they are using that as a catch-all. So as I said, currently 13 licensed producers listed on Health Canada's website, 5 in Ontario, 5 in BC, and 1 in each of Saskatchewan, Manitoba, and New Brunswick. And prior to April 1st, LPs were permitted to purchase their starting materials, seeds, or plants from other MMAR growers. That right ended on April 1st, and now your starting materials have to be obtained from another LP or by import with permit. The injunction, which I'm going to speak about in a minute, I don't think has changed that to my knowledge, so still the situation. What are the challenges for licensed producers? I think one of the big challenges that everybody's struggling with is the advertising restrictions. Under the narcotic control regulations, no person shall publish or furnish any advertisement to the general public respecting a narcotic. And the definition of advertisement is very broad as well. So, and you have to kind of couple that with the fact that you are required to have a website, and your website is required to be listed on Health Canada's website. And in my opinion, a website is an advertisement to the general public. So there is an apparent contradiction there. I have yet to receive any satisfactory guidance or help from Health Canada to understand that contradiction and to give further explanation as to what the boundaries of permissible advertising actually are. I've heard rumors that Health Canada has been telling applicants that it intends to issue a guidance document on advertising. I have not confirmed that myself. I haven't seen anything yet, but that would, I think, certainly be welcome. So in the meantime, how are applicants and LPs dealing with this? Well, the advertising restriction, obviously it applies to the general public. So I think that's one thing that's being keyed in upon, and advertising to other than the general public is being the focus, particularly probably physicians. And we're seeing tons of media stories and press releases. So to the extent that you can get the attention of the media, I think everybody feels safe that that's not advertising. And I think everybody's feeling pretty confident that press releases aren't either, because we're seeing a plethora of press releases coming out constantly by applicants and other interested parties. So what else can you do to develop your brand? You can have a distinctive name. That's certainly going to help, because if you look at the list of known applicants thus far, you're going to see a lot of names containing things like med, canna, green, various variations and combinations of that. So they all start to blend together after a while. So I think you've got to kind of go back to Marketing 101. Think about a name or a brand that's memorable, distinctive, and really going to distinguish you from your competition, and secure that brand through trademark registration. And then you got to also think about, keep in mind as well that Health Canada lists you on their list alphabetically. So there may be a benefit to being very high or very low on that list and not falling in the middle. And then think about whether you're going to be, you're going to try to be everything to everyone, or you're going to try to be a niche player. So are you going to specialize in strains to treat particular illnesses? Are you going to have premium strains at premium prices? Are you going to provide bargain prices? Are you going to be organic? What is the way that you're going to try to set yourself apart from everyone else? Another thing I'm seeing with applicants is an attempt to align themselves in some way with a medical clinic that specializes in assessing patients for medical marijuana use, usually through some type of a referral arrangement. And I've seen these clinics already advertising in the newspapers, which is a little bit questionable, but popping up in all over Ontario, Ottawa, Toronto, London. There was one in London actually that opened last month and then closed last week. And I'm not really sure what the reason was for that. But in any case, I think the success of that type of clinic is going to depend ultimately on how stringently this prohibition on advertising to the general public is enforced, and also whether the applicable Provincial College of Physicians and Surgeons is going to permit them. And I'll speak more about that in a moment. That's just a photo of the signage on the exterior of the clinic in London that closed last week. So having a marijuana leaf plastered on the signage on the outside of your premises, I don't know if that's going to be something that Health Canada is going to be cool with. So what are another more challenges? Municipal zoning. As I said, kind of step one when you locate your premises has got to be to consider whether you're going to have an issue with the municipality over zoning. So I think what everybody's been struggling with this, and municipalities across the country have been passing zoning amendments, bylaw amendments to specifically address MMPR use. The problem that they're having is that although most consider the use to be agricultural in nature, they want it to be in an industrial zone for various reasons. So some of those reasons include a lack of access to servicing when you're talking about very rural agricultural zones, proximity to emergency services, and the potential impact on neighboring agricultural lands. So what we're seeing is most municipalities deeming the use to be industrial and restricting it to industrial zones. There are certainly challenges already going on to the zoning amendments that have been passed. I know there's been a challenge to the Ontario Municipal Board of Ottawa's restriction setback requirement of 150 meters from any other residential or institutional zones. And there's also been a court proceeding commenced in Richmond Hill by an applicant whose council has determined their use to be an impermissible agricultural use in an industrial zone. So have to make sure you're on side with zoning. Another thing I've been seeing is an underestimation of working capital required to get into this industry. So the initial upfront costs for construction, for security plans, for the appropriate personnel in place are high. And I also think the initial estimates of the time to obtain a license are proving to be insufficient. So the time to profitability is much longer than was originally anticipated. And I think a good example of all of this is Tweed, which released its first quarter results last week. They didn't ship their first product until May 5th. So they had no revenues in the first quarter of this year, but they incurred expenses of $2.7 million in that quarter alone, which were attributed to construction costs, personnel, and the start of growing operations. So I think that certainly is a highlight of the need to be well capitalized in order to succeed. Another challenge is the reluctance of doctors to provide medical documents. You've got many doctors personally just feeling unsure and unsafe, feeling weary about being the gatekeeper for what they characterize as an untested and unapproved medication. Probably doesn't help that the president of the Canadian Medical Association is calling the use of medical marijuana quackery. But legally, the only restrictions that doctors are really subject to at this point are the provincial guidelines that, that apply in their province. So the 7 out of 10 provincial physician colleges have already introduced guidelines or standards of practice to specifically address providing medical documents under the MMPRs. Ontario's is under consultation right now, and I expect we'll see something at some point this year. Nova Scotia's is just a general policy dating back to the MMARs, so I believe they will ultimately pass something more specific to the MMPRs, and nothing yet from PEI that I'm aware of. So all of the guidelines really focus on there being a proper clinical assessment of the patient before providing a medical document and appropriate follow-up. But in addition to that, there's lots of little quirks in each of them. They vary quite substantially. So some prohibit Skype consultations, which is something that's actually being promoted by some clinics, so that's a concern. Quebec doctors can only provide medical documents to patients who are willing to participate in a research study. Alberta doctors have to actually register with their college as an authorizer of marijuana for medical purposes. Some provinces require that the doctor confirm that other conventional therapies have been tried. And some prohibit the physicians from dispensing to patients, although this is expressly permitted under the MMPRs. Some require that you must be the primary treating physician in order to provide a medical document, which I think is going to be troublesome for some of the types of chronic pain clinics we're seeing pop up, especially in BC and Ontario. Saskatchewan doctors have to require their patients to sign a treatment agreement. Some are prohibited from providing a medical document from a location which is provided by or subsidized by a licensed producer. So it's going to be interesting to see how the word subsidized is interpreted, but I think clearly that's meant to capture a referral fee relationship, so that's going to be a problem for clinics as well. Many of them restrict the physician's ability to personally benefit from providing medical documents or to have any interest in a licensed producer, which is not surprising. And one of them actually seems to strongly discourage patients from being able to purchase from more than one licensed producer at a time, which again is not something that's found in the MMPRs. A few other challenges. Securities regulators we're seeing both in Canada and the US, some strong warnings being issued regarding publicly traded companies involved in this industry, seeing words like fraud and pump and dump schemes, marijuana stock scams, because what we're seeing a lot of is press releases getting issued and share prices actually being affected by press releases that just say nothing really more than we're thinking about possibly getting involved in this industry. There's definitely a concern that by the regulators that the investor kind of frenzy needs to be tempered a little bit. So that could be a concern for licensed producers who actually do want to achieve public listing either through an RTO or otherwise. We're seeing pushback from patients regarding cost. Again, for sure the cost to buy from a licensed producer is going to be more than the cost to grow yourself. That's been, I think, one of the main precipitators of many of the challenges in court right now, which I'll talk about in a moment. There's currently a lack of insurance coverage for patients under most drug plans. Medical marijuana doesn't have a DIN or a drug identifier number right now in Canada, so most insurers won't include it in coverage under their drug plans. Now, I know there's been already an appeal decision in the state of New Mexico in the States where an insurer was ordered to reimburse an injured employee for medical marijuana costs. So I think it's only a amount of time before we see that type of a challenge in Canada as well. Perhaps it already is underway and I'm just not aware of it, but nothing that I've heard of thus far. And then, of course, just the difficulty in obtaining a license. So current challenges in the courts right now to the MMPRs. We've got RV Allard, which is a proposed class action started in federal court in November by 4 representative plaintiffs who are seeking to strike out the dried marijuana restriction as similar to what happened in the R.V. Smith case, and to permit continued personal production as was permitted under the MMARs. On March 21st, An injunction was granted in that proceeding which did preserve certain MMAR rights in certain circumstances. So Health Canada has published on its website its position on the injunction and what criteria you have to meet in order to qualify for that injunction. The exemption provided for in that injunction. And if you don't qualify and meet those criteria, then you are stuck with having to purchase from a licensed producer. The Crown has appealed the injunction, requesting that it be set aside, and the applicants have actually filed a notice of cross appeal, basically seeking to expand the exemption. Now, that appeal and cross appeal, I haven't heard anything about timetable or when that might be heard, but the federal court has created a timetable for the action as a whole, and if all goes according to plan, it's going to be going to trial in Vancouver in February next year. So this should be of interest to licensed producers, because if the courts ultimately determine that a right to personal production has to coexist with the MMPRs, then this will have some impact on the market for licensed producers. I'm not really sure how much, but it will have some impact. As of May 7th, there are also 222 individual actions that have been filed in the federal court based upon a standardized statement of claim prepared by marijuana activist John Trammell. And those claims seek a total repeal of the MMPR's legalization of marijuana, or in the alternative, a personal exemption. So I know that, I'm not sure today how many of those claims have actually been filed. I know it's much more than 222 now as they continue to be filed. The Crown brought a motion to stay all of those actions and put them on hold, essentially saying that the Allard case will determine some, if not all, of the issues in those actions as well. And the court on May 7th agreed and ordered that they all be stayed, but clarified that anybody who meets the criteria in Allard is entitled to the same exemption. And if you don't meet the criteria in Allard, you can still start an action which will be stayed, but you will be permitted to proceed with a motion for your own personal exemption. So I know that many of those motions have been filed. Nothing's been scheduled yet. I suspect they'll all be consolidated and heard together. There are also a number of other marijuana-related MMPR court challenges going on across the country, but I think they're mostly related to the defense of criminal charges. What are some of the opportunities? Well, obviously this is an industry that Health Canada itself predicts to be worth $1.3 billion by 2024. Some believe that's a very conservative estimate, and certainly it will be exponentially larger if recreational use is regulated and legalized. The leader of the federal Liberal Party in Canada, Justin Trudeau, has been very vocal about his position that recreational marijuana use should be legalized through regulation. So this will undoubtedly be an issue in the next federal election and may certainly impact when we might see that regulation take place. But certainly an MMPR license would be a valuable foothold into any regulated recreational use market. Seeing lots of spin-off businesses already. To be an LP yourself, you're subjecting yourself to a very regulated industry, huge startup costs, licensing uncertainty. We're seeing all sorts of other ancillary businesses. QA people are needed, security consultants are needed, laboratories are needed for testing, software providers are needed to fulfill the record-keeping obligations. We're seeing all these web hubs developing that are trying to link together, provide information to patients, to doctors, to link them with licensed producers. Former police officer has opened a cannabis lounge in Winnipeg. We've got venture capital firms that are devoted solely to MMPR ventures. We've got conference and workshop providers. So, and of course we've got clinics, which I spoke a little bit about, but as they say, how that develops is really going to depend on how the positions are regulated in the applicable province. And Tweed was the first to go public here through an RTO, and we're certainly seeing many press releases issued on an ongoing basis announcing letters of intent and various steps to further toward other RTOs. So we're certainly seeing that The investor appetite in this industry continues to be pretty voracious, maybe leveled off a little bit from the initial hype, but certainly there's still a lot of action there. And finally, what are my thoughts going forward? Well, there's a lot of balls in the air right now. I think that's obvious, and things are literally changing on a daily basis. But I do think there's going to be significant consolidation in the industry. I don't think we're ever going to have hundreds of licensed producers independently operating. I think as more and more licenses come online, I think we're going to see a lot of mergers and acquisitions and some of the smaller producers getting eaten up by the bigger ones. I'm hoping that we're going to soon get some guidance documents from Health Canada that are going to both help at the application phase and also the post-license phase. That's going to give a lot more certainty to how who can get a license in what circumstances and how to operate once you get a license. I hope that we're going to get a court pronouncement on the constitutionality and enforceability and validity of the MMPRs. I think, as I said, the outcome of the next federal election is going to certainly have a large impact on the forecast that we could give to when we realistically might be looking at a regulated recreational use market. The comfort level of doctors, I think, again, we're going to see how the rest of the provincial guidelines play out. I'm hoping that as more and more people approach their physicians asking about medical marijuana, doctors will take it upon themselves to educate themselves, hopefully become more comfortable with it, make it easier to obtain a medical document. And the last thing I just wanted to mention was that another interesting issue that's starting to emerge as this industry explodes is employers' rights and duties with respect to employees who use medical marijuana. So recently in Canada, we've heard in the media that there was an RCMP officer in New Brunswick who was smoking marijuana while in uniform and in public. Now, he was doing so pursuant to a license that he had to treat for symptoms of PTSD. But the RCMP took the position he couldn't do so while he was in uniform or carrying a firearm. So it raises all sorts of interesting issues. Employers generally have a duty to accommodate their disabled employees to the point of undue influence. So what exactly does that mean in the context of medical marijuana? Can you prohibit smoking it on the job site during work hours? It is a medication. Do you have to provide a designated smoking room for them? There's all sorts of interesting issues that are created here. We'll see how that all plays out, but I think ultimately it's going to affect the public perception of medical marijuana use, which will in turn affect demand. So I'll be interested to see how that goes. So that's really all my comments that I wanted to address today, but I see there have been some questions that have come in, so I'll try. Let me see if I can just zip through those and address them for you. I've heard that Health Canada will place a limit on the number of MMPR licenses granted. Is this true? Not to my knowledge. If you look on the Health Canada website, you look at press releases they've issued and statements made, they've been very consistent in saying that there's no cap on the number of licenses that will be granted. And in fact, I don't think they would be able to impose a cap on the number of licenses the way the MMPRs are drafted, so I don't believe that's the case. That being said, there certainly haven't been a lot of licenses granted as of late, and I think that's maybe why everybody's starting to get nervous and these rumors are circulating, and I'm not sure why that is the case, but I'm hoping that we're going to see more and more licenses coming onto the scene soon. What happened to the hundreds of kilograms of cannabis that Health Canada purchased earlier this year in anticipation of the MMRP access problems? That I do not know the answer to. Sorry, you'll have to ask Health Canada that question. Okay, and then one other question that was posed was someone saying that their security clearance was the last item that they were told before they received ready to build notice, and that it comes close to pre-license inspection. I mean, this doesn't surprise me because I myself have received inconsistent information from Health Canada on various occasions on particular topics. So all I can tell you is that the 6 steps and the sequence of those steps was what was conveyed to me by Health Canada about a month and a half ago. and that's the best I have to go on. So if you were processed earlier or later than that and in a different way, it's just as a result of Health Canada really feeling their way through this and things evolving and changing as time goes on. Are you aware of any phased license system whereby prospective LPs are granted permission to cultivate before a full license is granted? I'm not aware of that, although information that I have received is that that has been happening to some extent. And how that's happening and whether it's fully endorsed by Health Canada, I don't frankly know. And that would have to be specifically addressed with Health Canada to get their formal response on it. And how are they acquiring starting materials? So again, as I mentioned, at this point, the fact that certain individuals are continuing to be able to grow personally pursuant to the injunction in a LARD, as far as I know, that does not allow a licensed producer to now buy starting materials from those personal growers. As far as I know, that right still ended on April 1st, and if you are in need of starting materials at this point, you have to either buy them from another licensed producer or you have to import them from outside of Canada. As regards to the approval of the QA persons, what factors are considered and what criminal convictions will result in a rejection? I've asked this specific question about what criteria are required or what qualifications or requirements, and this was another situation where I got an answer that I felt wasn't wholly satisfactory, but the response I got from Health Canada was your proposed QA person should read through Division 4 in the MMPRs, which relate to good production practices, and they should be able to confirm that they've got experience and expertise in all areas mentioned in Division 4. So they weren't willing to commit to any particular degrees or certifications or anything of that nature that would be helpful or determinative of whether your QA person would be approved. But you certainly want to get somebody who has a great deal of experience in this area, not necessarily with medical marijuana, but with pharmaceuticals, and who can read through Division 4 and tell you confidently, yes, I can do all of this, no problem. As far as criminal convictions go, I really don't know. I haven't heard of that. Remember, QA persons are not one of the people that are required to get security clearance, so that's not an issue. I don't know that Health Canada even does a criminal records check on the QA person, not to my knowledge. They have to submit a CV, but I didn't think they did any further background checks on them. I could be mistaken, but not to my knowledge. Aside from the Netherlands, where might seeds be imported from? Canada doesn't put any restriction on you as to where you can import from, other than to say that wherever you do import from, it must be legal for them to export to you. So where exactly that is right now, I couldn't tell you offhand, but so long as it is not, like I say, illegal for that person to export to you, and as long as you obtain an import permit, you're fine. Any special issues for U.S. businesses who are thinking of investing in a Canadian medical marijuana business? Not that I can think of. I mean, there may be, you'd probably want to look at it from a tax perspective and get accounting advice on what the most tax-effective way to invest or get involved might be. But as far as legal issues, I don't see any. If you're planning to be the applicant yourself, of course, you have to meet the criteria of having your head office or a branch head office in Canada. But if you're merely investing through the purchase of shares, then no. As far as regulatory issues, I don't see any. So I think we're at 3 o'clock now, so I'll wrap things up. I'll take a look through the questions submitted by chat though later, and if there's any of you that I wasn't able to respond to, I'll try to get a hold of you individually and address your questions. And certainly you can feel free to contact me as well. I've put my contact information on the last screen. Feel free to follow me on Twitter at Trina Fraser. I do tweet pretty regularly on the industry and what's happening in Canada. And I'm happy to speak further to you if any of you would like to.
Great job, Trina. Thank you so much for taking the time to speak with us today. That was a lot of information. Before we sign off, I just wanted to let each of you know that in the next few days I will distribute a copy of her presentation as well as a recording of this webinar and her contact details. Like she mentioned, please do not hesitate to reach out to her if you have any questions that weren't answered. And with that, I just want to thank everybody again for joining us, and I hope you have a great day.